George Goulburn is here. I'm going to mention you by name because you're actually on our advisory board. The public lecture series is derived from the Australian Centre for Justice Innovation, which is a centre here at Monash, which is located in this building. And we're involved in research in relation to justice issues, as well as involved in education, training and consultancy work in relation to justice issues. And justice is defined very broadly to include, of course, not only what happens in court, but also what happens in the much broader justice system, which includes alternative dispute resolution. In any event, we'd be very grateful if you drop your cards into the box outside if you haven't already, and we will send you emails in relation to future public lecture events. It's my very great pleasure tonight to introduce another speaker in our series, and it is not Robert Cialdini. And I'm not quite sure why he's there, but no doubt all will be revealed. But a few people walked in and said, you know, Tanya, I thought that I was actually here for somebody else. And I was saying, no, it's Robert Cialdini. So that's how I might introduce you tonight. Okay, Robert? Gary Weiner has been teasing me all week because I got his name wrong last week. But I've got it correct today, or should I just call you Bob? We're delighted to welcome Gary Weiner. He's the Mediation Program Administrator for the Court of Appeal in the First Appellate District, San Francisco. And he's actually been mediating since 1983. So he has a very rich background and history in mediation. And I think it's very interesting because he took over a very large mediation program with a number of mediators and tried to work out what actually worked in mediation, what made it effective, and how he could actually set up an effective referral program. So for those of you who are here from the Small Business Commissioner, really interesting insights about how you might select cases or think about who you send a case to. I've had the great pleasure to get to know Gary through his work on the ABA committee, which is really focusing on how you can assess effectiveness in mediation as well as other forms of ADR, and very much around qualitative and quantitative work in terms of that assessment in respect of ADR. Gary has a very interesting background because he originally went to Cornell, and you studied psychology in Cornell, that's right, and then I think like some others in Australia as well, we've read through the Solicitors and Barristers Admission Board or something like that, but not a formal university education in law, but an applied education in law before sitting the bar exam. As I said, we're delighted to have Gary here, who's got a really interesting background, and I hope will be interesting for you this evening to listen to. In terms of how we normally run these public lectures, the process will be that we will have Gary speaking until about 6:45, maybe a little bit beyond that, and then we'll have time for questions before closing at 7 o'clock. Can I just say again how delighted I am that you're all here today, and without further ado, hand over to Gary. Thank you, Gary.
My name, Mike, that's very impressive. Hi. This is Robert Cialdini, that's not me. Robert Cialdini, I'm going to make sure the buttons are doing what they do. Okay. This is Robert Cialdini's book. I've never read Robert Cialdini's book, but I recommend that you do. He talks about 6 principles of persuasion. And of course, this is a lecture about mediation. You may wonder why would I start with Robert Cialdini, but stay with me for just a moment, if you don't mind. He's a psychologist, University of Arizona in Phoenix. 6 principles of persuasion: liking, in other words, you can be a persuasive person as long as people like you. Social proof, meaning if people that I like are doing something, I'll be persuasive. If I can convince you that people you like are doing something, it's easier for me to persuade you to do it too, okay? Scarcity, going out of business, don't miss out, the sale is going to be over in 5 minutes, get it while you can. Commitment and consistency, if I can tap into how you see yourself positively and convince you that the thing I want you to do is something that fits your image of yourself, you'll be more likely to be persuaded. Reciprocity, a very simple thing, do unto others as you would have them do unto you. Is this is really a cool thing. This factor of persuasion was identified by a psychologist at the University of California in Santa Barbara. And what he did is he sent out Christmas cards to 2,500 random people in the United States. Do you do Christmas cards here? Okay, Christmas cards, big thing in California, I mean in the United States. Hallmark, I think, invented the idea. So he sent out 2,500 Christmas cards one year to people he had never met, random selection people, and waited a year. And not surprisingly, really, he got back like 1,000 Christmas cards addressed to him, complete and utter strangers. These people had never heard of him before. And so he put them on his list and sent them Christmas cards again the next year. And then, you know, the number tailed off a little bit, but for 3 or 4 years, he was getting Christmas cards from people who were complete and utter strangers to him. And in fact, he tells the story about how one family to whom he had sent the Christmas card wanted their kid to go to UC Santa Barbara, and they, you know, dear psychology professor, whatever his name was, we're coming to Santa Barbara, thank you for all these communications. He said, would you help me? So sure, he helped them and got their kid into Santa Barbara. But the most important one of the 6 principles of persuasion is authority. And that is, if people think you know what you're talking about, they'll be more likely to do the things you want them to do. And one of the tricks that Cialdini identifies in establishing authority, this is why, this is the punchline, okay? So one of the tricks that Cialdini identifies in establishing authority is to, right up front, acknowledge what you don't know. So I have 2 things to show you that establish my authority. One is this certificate from the Victorian Association of Dispute Resolution that says that I am a credentialed mediator in Australia, which is quite remarkable. This is I posted a copy of this on my Facebook page. I don't know that you can read what I wrote, but it says I'm now a certified mediator in Australia. This is for my friends. Torn or nothing, going to Sydney and Melbourne in September. They are actually asking me to talk. Those of you who know me well are probably engaged in endless eye-rolling now. Well, to you, neener, Gary Weiner. That's what I do want to say to you that I am not a scholar. I'm not an academic. I didn't even finish law school. I quit law school after 2 years to play in a rock and roll band. Then eventually read the law in a law office instead of going to law school. I'm not a scholar. Okay. This, that's Cornell University in 1971. The sad-looking woman on the left was a woman about to become my wife. That's Joanne. I'm the guy with the cigarette in the white shirt. The guy on my right is John Kaplan. He's a securities litigator in New York now. I show you this because this is 1971. This is Professor Frank Sander from Harvard, whom some of you may know about. How many of you are mediators? Oh, a room full of mediators. Good, okay. So Frank Sanders from Harvard, he was the guy around whom the Harvard program on negotiation was built. Frank Sanders spoke at a conference in the United States that took place only 5 years or so after my graduation from Cornell. So there was some synchronicity in time. The reason why they're both there is because I'm going to tell you a story about how So I'm going to tell you a story about how mediation came to be where it is in the United States anyway, and I think it's sort of like what happened here in Australia. I ran this by Tom, and she said, yeah, it's sort of like. So there were 2 streams, the hippies and the judges, okay? So what I mean by that is that there was around the world, and in a lot of places in the late 60s, early 70s, there was this cultural change that took place, and one of the manifestations of that cultural change was that there's a renewed sort of doubt about the institutions, the validity and the authority of institutions that were governing us in the United States. We were experiencing the Vietnam War. Many of us were starting to learn that there were a lot of lies being told by our government to us. That was the time when Richard Nixon was president, and it was also the time of Black Power, and power to the people was a slogan of the Black Power folks, but it really tapped into, I think, a deep-seated questioning of institutions of governance and other social institutions. One of the results of that was the growth of community mediation that sprung from this notion that we would like to, in our communities, resolve problems ourselves, thank you very much, according to standards that we feel comfortable with and in ways that we feel comfortable with, using our neighbors as the helpers in this mediation, in this process that became mediation. At the same time, this conference that Frank Sander addressed was going on, and this is the other stream, this is the judges' stream. It was in that period when, at least in the United States, courts were beginning to identify a problem with dockets. It was taking way too long for cases to get resolved, and the cost of litigation was beginning to increase. Courts and judicial officers were looking for ways to help solve that problem. And Frank Sander was asked to, so he was a professor of law at Harvard, was asked to address a conference called the Pound Conference, which was asking the question, what do we do to help move things along in courts? So he gave this now somewhat famous lecture about the multi-door courthouse, looked into mediation, thought that might be a good thing for courts to look at as a way of getting cases off of the docket. That's the thumbnail sketch of the history of mediation. Actually, I think we're not much further along than that today. One of my themes is, though, that each of those streams brings with it a sort of received body of wisdom that leads to a set of tensions that we experience in the mediation field right now. In the court-connected context, in the mediation of litigated cases, there is a tension between the urge, the need for docket clearing. My court measures the success of my program based on how many cases I get rid of. We also know that people in the mediation community believe that mediation serves a whole other set of values, understanding, repairing relationships. In my court, they want me to get rid of cases. So there's a tension there between the impulses and these other values and docket clearing. Within the mediation community, there's also, I think, a tension. And this is I'm really, really excited that my life has brought me to a place where I can use the word epistemological, and it actually is not just showing off. I think we have an epistemological tension in the mediation community, which is between the impulses that arose back when the hippies started, shorthand, hippies is just shorthand, okay? When the hippies started mediation in the community mediation world and in the mediation movement, and the new sort of awakening about brain science and decision-making science and all that. Where do we look for wisdom and knowledge about how to be mediators? I'm going to skip through that. Okay. So as Tanya mentioned, I inherited this program that had been in existence for 10 years. And there were it's a program in which I decide which cases that are on appeal are sent to mediation. And we have a panel of 230 mediators from around the San Francisco Bay Area who've agreed to provide a few hours of free time in exchange for getting referrals. And I had lived up in Sonoma County, which is about 70 miles north of San Francisco, for a really, really long time. Took the job in 2009 and inherited this panel of 230 mediators. I knew maybe 30 of these people personally, and there were 200 that I didn't know. And my job was going to be to send lawyers who I had never met, who had clients who I had never met, to spend a long day with a mediator that I had never met to deal with one of the most difficult things that all these people have been dealing with, a case that had actually wound up in the Court of Appeal, which meant that they had spent years probably and lots of money and lots of energy on this dispute, and it still wasn't over. And I was supposed to decide from who to send these people to. And I was troubled because I hadn't yet come across a solid body of knowledge that I felt would provide me a comfortable base from which to select mediators to mediate on people that I hadn't met. So what my inelegant solution was simply to meet with as many of the mediators as I could get my hands on. In the first couple months I was there, I did about 140 one-hour interviews with mediators. I drove all over to find these people because I had the luxury of an intern early on. I said, find me all the research that tells us what a good mediator is, and there was very, very little. So I figured that as long as I could feel comfortable that I could sit in a room with this person for an hour, and by the way, in these interviews, we never talked about mediation. I just, tell me about your family, your kids, and I wanted to know whether I could feel comfortable spending an hour with this person before I would send people to them. And it sort of turned on this thing that I've been pursuing ever since, which is, how do we know what's good? We have trainings. In Australia, you have this accreditation program. And there are models, and there is a received body of wisdom. But I don't know how we know what's good. I have some ideas about how to find out. I think that we all operate according to some understandings. Some of them are beliefs. Very few of them are empirically derived from an empirically derived body of knowledge. So I'm going to outline what I think is a useful intellectual framework or an analytical framework to try to figure out what's good. First of all, we have to know what it is that the goal of mediation is. Now, like I told you, in my court, the goal is to settle cases. And frankly, the administrative presiding justice of the Court of Appeal, he doesn't care how the cases get settled. If they get off of his docket, he's happy. When I took over the program, the settlement rate went down a little bit, and I was a little nervous that I might not be called back to serve in another year. There are a whole bunch of other goals. Across the street from my court is the Northern District of the Federal Court, the U.S. Federal Court. It's a trial court. There's 3 mediators there. They have a program in their court rules enunciate a whole set. This is the whole set of values that they have. They no longer keep track of the settlement rate in their program. Okay? And it's a very long-standing program. And I know that among mediators, defining success is a topic of some conversation. So somehow we have to at least know what it is that we're trying to accomplish. And then, once we know what it is we're trying to accomplish, and let's just assume for the sake of conversation that we're trying to settle cases. I get it, there are other things that mediators do that are valuable, but let's just put aside to quarrel about that and assume for the rest of this time that settling cases is the goal. Well, then we need to, I think, to know what makes a good mediator is find out which behaviors of mediators tend to achieve those goals. Asking the question, what should mediators actually do if they want to help people achieve the goal? My favorite word again. Underneath the question of what should we do is how do we know we should do that? Right? Where does the knowledge come from? I looked up on the internet something about science and psychology. When I was a psychology major, Cornell was an experimental psychology school. We electrified rats. We did all that stuff and made them run around in mazes and everything. This is how some knowledge has been up. Do you guys know what this picture is? This is the famous Milgram study where they made people pretend they convinced people they were giving people shocks to make them cooperate or something, and then people were turning this thing up and the guy was screaming, you know this thing, right? So that's one way you can find out stuff. And then of course now we've got neuroscience and we're finding out things about how people's brains work. So there's lots of places to look for the kind of knowledge that mediators seem like they ought to have. This is my manifesto. We need to be gathering information using science as well as we can, but specifically, not about how the brain works, not about how decisions are made, but what do mediators do? What behaviors work? For those of you who run programs or are involved in programs, I think the approach has got to be the same for the program. What are the program's goals? And we have to understand that in order to have good programs, we have to have good mediators. And therefore, we need to know what makes good mediators before we can have good mediation programs. Just as a little demonstration that some of the things that we have carried around, I think, as received wisdom are a few little examples here. When I was trained as a mediator, these things were all part of the training. I will take them one at a time. Don't bother reading this. Basically, this is sort of an older post. It says that if you're going to do a good job as a mediator, you've got to give the parties a chance to vent, to blow off steam and reduce their tensions. Well, that's not true exactly, because we've now learned that, Daniel Goleman, emotional intelligence, we've now learned that, in fact, if it's in an unmanaged way, and if allowed to go on for too long, venting actually makes people less cooperative and less empathic and less able to use the kind of thinking and decision making that we actually think we're trying to help them get to in mediation. There's another thing that I was told. I took a week-long course in multi-stakeholder collaborative decision-making, and boy, they were very excited about this brainstorming process. The brainstorming process is defined, put the ideas on the board, nobody criticizes the ideas, just get them all up on there, because we're going to develop a set of criteria later to judge them by. Well, no, as a matter of fact, that's not a really great idea, because Charlene Nemeth, who teaches at the University of California at Berkeley in the psychology department, has found that if you do that process, you actually miss out on some awfully darn good stuff that you get if you allow people to brainstorm and actively engage with the ideas and the options as they get put up. You get deeper, better, more useful ideas. Okay, the next one is have both sides tell their story. This is like the article of faith of mediators. Two parties, they're mad at each other. You got them sitting at the table. You let the first party tell their story. You make sure they feel heard. And then you turn to the second party and you let them tell their story and you make sure they feel heard. Everybody's got to be heard, right? Well, not necessarily. Rebecca Sachs, I haven't got a citation for you, but if you Google her, she's at MIT. she's done some interesting work. She's found that at the mediation table, if you have people of disproportionate status and power, and you give the lower status, lower powered person an opportunity to tell their story and make sure that they feel heard, both the lower powered, lower status person and the higher powered, higher status person will tend to be more empathic and more collaborative. But if you do the same exact thing with the high powered person, the levels of easily accessible empathic tendencies and cooperation go down in both parties. Got that? All right. So we say give both sides an equal opportunity to tell their story. We teach people, when you're telling your story, I look at you, I ask you if I have your story right, I repeat it back to you, ask for your patience while I then turn to you and ask you your story now. But if you have people in different power statuses, doing it exactly equally reduces the empathic capabilities of both parties when the high power person gets that kind of attention. We also have a language that we use all the time about mediation. We have the evaluative versus facilitative, or the director versus facilitative. That comes from an article that was written by a guy named Len Riskin a couple of decades ago. The forms that my court uses, ask the mediator to describe their work at the mediation they did by describing it as evaluative or facilitative. It's in the form, it's in the court form. Well, Len Riskin wrote articles about 4 or 5 years after he wrote the first article that said, you know what, I got it wrong. But it was too late. Everybody in this room who's a mediator knows the words facilitative and evaluative. Everybody who's a mediator in this room thinks about the mediation practice from the viewpoint of facilitative versus evaluative, but the guy who invented the concept disclaimed it 5 or 6 years later. He has a whole other set of crazy, which we can talk about some other next time I come back to Milburn. So that's the sort of the manifesto part. I was also asked to talk about what do we actually know that's been sort of empirically verified. We know a few things. We know that people like mediation. Almost all the studies of mediation, no matter what kind of mediation it was, no matter how the parties got to mediation, process satisfaction is high. People like mediation, they like the process. People like mediators, which is nice if you're a mediator, of course. One of the things that my program did generate was about 1,200 evaluations over a period of 10 years that were tendered by lawyers, parties, and some insurance claims people who had been attendees at mediations about the whole range of mediators. Not a whole lot of responses for each mediator. We had about 1,200 responses, and I had a sociologist working upstairs. I said, you know what, we've asked these people 2 questions. One, would you use mediation again? And 2 is, would you use this mediator again? And I asked the sociologist to run the numbers for me to see if there's any difference between how people felt about the process and the mediator, depending on whether the case settled at mediation or not. And interestingly, there's a statistically significant difference in our sample of 1,200 responses. There's a statistically significant difference between the settled group and the non-settled group, but it's tiny. 75% of the people in our population whose cases settled at mediation said they would use the process again, and 70% of the people whose cases didn't settle still said they would use the process again. And the same numbers hold for the mediators themselves. So we can be pretty confident that people like mediation, even if it doesn't, quote, work, right? There has been no proven, and I'm sorry about this one, Ann, but there's been no proven and demonstrated correlation yet found between the fact of having been trained and settlement of cases. There's been no proven correlation between subject matter expertise and settlement of cases. We do know that if you have as a goal settling cases, you should violate all of the things that Anne and Tanya and I are teaching the people upstairs. You should pressure people into settling cases because that seems to actually get them to do it. But I'm not going to say that upstairs. Dean Pruitt is one of the authors of one of the only books, I think the only book specifically devoted to mediation research, along with Ken Kressel, who Tanya and I have been working with quite happily over the past couple of years. Dean Pruitt did a little bit of a sort of where we are, what do we know so far. So basically, Dean, he's still alive, he's a pretty old guy. This is very recent work of his, sort of summarizing his own knowledge base. Mediation is pretty useful when the conflict isn't severe and the people who are coming to mediation want to resolve the conflict. We also learned that mediators ought to be quiet if the parties are actually doing a good job at working out their problems. These are some of the things that he finds that this is a review of all the extant actual research on mediation, okay? This is Dean Pruitt's grand master view of what we know. He also says that we haven't really learned that much, that there haven't been very many studies that actually show the effectiveness of a specific mediation strategy, and here's some more of his critiques of what we know so far. Craig McEwen, not a lawyer, a student of mediation, however. He's a professor of political economy. He was to have presented in DC with Tanya and I, and this was his, these are some of the things that he would have said had he been there. Basically, cases settle pretty well in mediation.
Sorry, could you just go back to that?
I could do that. Okay.
I don't understand what you mean by 30% and 60%.
Oh, yeah, that's not well done, is it? Somewhere between those numbers. Across programs, if you look at mediation and civil cases, almost all the programs about those numbers sell, somewhere between 30 and 60%. The settlement rate is a little bit higher in divorce and custody cases. But interestingly, Craig McEwen also points out that most cases actually settle even if you don't go to mediation. We know that even before mediation was institutionalized in the court setting, only 2 or 3 or 4% of cases in jurisdictions all over the world actually wound up going to trial and having a verdict. According to Craig's analysis of the extant research, it's not really quite clear that mediation makes that much of a difference. Sorry. He does say that there are some contextual factors that affect whether or not mediation is helpful. It does point out that mandatory programs where people are told you've got to go to mediation whether you like it or not, and voluntary programs where people get to choose whether to go to mediation or not, the settlement rates are pretty much the same. We did this pilot when I ran a trial court mediation program from 2000 to 2004, which was part of a study conducted by the Judicial Council of California. We had 2 courts that were mandatory courts, 2 courts that were voluntary courts. The settlement rate process satisfaction was pretty darn close in both the mandatory and the voluntary courts. Mediation, the litigated civil case, Dr. McEwen finds cases are more likely to settle if mediators are more evaluative and if they recommend a specific settlement. Okay, again, I won't tell Anne, I promise I won't tell anybody upstairs that. They do find, though, that in divorce mediation, a problem-solving approach, not necessarily a quote facilitator, but a problem-solving approach is effective. Of course, the research also shows that what the lawyers do makes an awful lot of difference about whether cases settle in mediation. That if lawyers prepare their clients to actually resolve the dispute, and if the lawyers behave themselves as if they were interested in resolving the dispute, then the mediator's job is made a little bit easier. Right? That's too long. Okay. Jim Wall, and do you people know her? She's from Australia. Did you know her? She's from Australia. He's not. She's at University of New South Wales School of Organization Management, and you don't know her. I'd like to introduce you. I don't know her either, but she worked with Jim Wall on this study, and Jim was part of our group with the ABA. They studied 62 civil mediations. Pardon? You don't know the study? Well, stick around. So they did a really thorough qualitative analysis of 62 civil cases. These were basically personal injury type cases. And they made 4 predictions about these cases before the study was begun, that mediators would be successful. A mediation would be successful, there's a lot of cases would settle, that the mediators would try to get people to lower their demands, that they would be more likely to pressure plaintiffs because plaintiffs make, I'll use this word, but I'm just kidding, okay? Plaintiffs make unreasonable demands to start with. Why? Because they know that it works, actually. That is, this social science tells us that if you start high, you get closer to your goal, and if you start at what people might call a reasonable demand, it just works. And so mediators know that in advance and expect it to happen and are prepared to press plaintiffs more because they know that the plaintiffs have come in with that in mind. And that as mediators began to believe that the cases were going to elude resolution, they used more and more pressing tactics. Right? And they did find out that, in fact, their predictions were right. A lot of cases settled. We know people settle cases in mediation. And they saw what they predicted. I'm going to skip around a little bit here. Okay. Yes?
Was there any difference in those cases, for example, if lawyers were present?
Oh, these were all litigated cases with lawyers present.
And all U.S. cases?
All U.S. cases with U.S. lawyers present, yes. U.S. plaintiffs, personal injury lawyers, and insurance defense lawyers. Okay. So these are right, so these are mediations, right, where it's a car accident, right, and the defendant driver's not there. Right? The insurance defense lawyer is there, and the claims adjuster is there, and on the other side you've got the poor person with a broken leg, right? And their lawyer. I'm going to skip through this stuff. One of the things that troubled them was that they couldn't really isolate what it was that the mediators influence, where the mediators were able to actually exert influence. Even though pressing tactics were more highly correlated with settlement than not, it was hard for them to identify what happened in the mediation when these pressing tactics were used that actually effected the change. Right? This is something that we should tell people upstairs, and I'm helping Ann and Tanya do training upstairs. We should tell them that mediators should acknowledge that settlement is to some degree outside of their control. So take the anxiety out of it for mediators. The study generates some advice to the parties, including prepare yourself to settle the case, basically. Figure out where you want to go, figure out how you're going to get there, and for the lawyers to actually work with their clients to get them ready to settle. If you read this article, this 2008 article, this is actually kind of amusing to me. They found 80 articles that had been published in the last decade, from 1998 to 2008, in which mediators were told that there was a whole list of things they ought to do, okay, including this list here. But Jim and Suzanne found that the list is, they say, the list is not that useful because mediators really don't have that much influence over the outcome of the mediation. And that, in fact, the real power over what happens is in the hands of the parties. I didn't write this. This is what Jim and Suzanne say. We don't really know what's going on. Okay. Let me talk to you a little bit about Ken Krussell, who's the co-author of the book on mediation research. By the way, the most recent volume, the most recent edition is the 1986 edition. So there hasn't been a mediation research book published since 1986, which in my calculations about 26 years ago, right? For the math. Ken is a really interesting man. Ken's a psychologist at Rutgers University in Newark. How am I doing in time? I've got 5 minutes. Okay, well, let me just close this. Ken is doing some really fascinating work. Ken is, let me explain it in quick order. He posits that there are two models that we mediators carry around with us. There is the explicit model of how we practice, a model of practice, or a MOP. We have the explicit model of practice, which is what we tell people we do. Ken and his research folks have done exhaustive interviews with mediators and asked them to explain their model of practice. How do you do the job that you do? And then they've gone and watched these people actually mediate and videotape the mediations and have extracted from the videotapes what the mediators actually do as opposed to what they say they do. And I guess you're not going to be terribly surprised, given what I've been saying so far, that they're not the same. They're not the same, and in fact, well, somewhere in here, since I only have now 3 minutes, a little bit longer. Well, okay, I'll go to the. All right, so what happens is that, in shorthand, is that mediators basically rely on their gut when they get into the mediation room. That despite all of the hundreds of hours of training many people have had, and despite all of the court rules and the standards of practice, and in Australia the accreditation, Ken found, at least on the east coast of the United States, that when you get into the real mediation room, mediators are basically sort of just winging it. I'm sorry. One last little thing. So, I've been saying it's really important, I think, for us to actually do some really solid research on what mediators do and whether it works and how it works, so we can teach people something that's actually effective. I'm coming back to Robert Cialdini, and I want to talk for just a minute about behavioral science and neuroscience and all that. It's very exciting to read Jonah Lehrer, well, although he's been sadly discredited because he made up some stuff that Bob Dylan was supposed to have said. It's fun to read Jonah Lehrer. It's fun to read these Daniel Kahneman's Thinking Fast and Slow. It's fun to read all this stuff. It's great fun to look at neuroscience blogs and see what the latest neuroscience is, and we can learn that there's the amygdala and it does all this emotional stuff, and you can't make good decisions without the emotions being involved, or you can't make any decisions without emotions being. It's all great, and we as mediators think, oh man, we know something now. We know about how decisions are being made. I am concerned, however, that we are going to begin to absorb this knowledge and develop ideas about practice in the same way we developed our original ideas about practice, which is going to be based on beliefs and assumptions about what we ought to do in light of the fact that we now know, for example, that that emotions are really, really important, and you can't separate the person from the problem. And then I'm going to, Cialdini persuasion, what I just skipped through is a sort of a contrarian view by a guy named Doug Frankel from one of the fancy schools in Boston, about whether mediators are actually in the persuasion business or not. And in fact, as he argues, it may very well be that the tools of persuasion are actually maybe some of the most important tools mediators can and in fact ought to be using. It's an argument that does not resonate immediately with mediators. We ought to find out. We ought to find out. We ought to teach mediators about persuasion. We ought to watch mediators do what they do and see if what they're doing is persuasive tactics, and if it fits into those 6 principles of persuasion, and we ought to do some research to see what effect it has on people. And then last night, this is the latest breaking news from the neuroscience front. I was listening to this podcast. There's this really cool podcast from the BBC called Philosophy Bites. Nigel Warburton and somebody else. And he had a neuroscientist on who said that they've now learned that if you increase the levels of serotonin in people's brains, they become more cooperative. And she was talking with him about the use of this knowledge in conflict resolution. She's not a mediator, not a mediation scholar. And they were engaged in like a 5-minute, I wanted to play this for you, but they were engaged in this 5-minute conversation about when will we start giving people pills when they come to the mediation table. Because we now have some ideas, we have some knowledge about this, so we'll get, that's the latest news from the front. So I'm now almost done. What I came all this way to tell you is that we don't know very much. That we should find out. And that the only reliable way to do that is to do some good science about what it is that we do every day. And I am incredibly moved, honored, thrilled, excited to have been working with Tanya over the past couple of years with the ABA toward these goals. What I'm hoping is that 30 years from now, there will be a place somewhere, either a cyber place or a real place, or maybe a combination of both, where there will exist a comprehensive and accessible body of empirically derived knowledge about what mediators ought to do. And with that, I thank you so much for your kind attention.
Now we actually have time for questions, and I can see Michael over there. So I'm just going to see.
Gary, I don't have a question, I've got a statement for you. It's obvious that you know too much. We're going to have to shoot.
Oh. Please don't shoot
The
me.
game is up.
I'm just a messenger, don't shoot me.
That's all.
That's a very friendly way of starting off questions.
Everyone else is very friendly here.
Again, a really fascinating lecture, and really, presenting some really diverse views around what the research findings are. But I'm going to check, because George, you've nearly got your hand up, and I'm assuming you might want to ask a question.
Well, firstly, congratulations on a politically incorrect approach to mediation. Well done. I was going to ask you why you bothered interviewing all these mediators. I mean, in Australia, the parties select their own mediators.
Okay, so my job is...
And the marketplace sort of sorts out,
right,
who's a good mediator and who isn't a good mediator, or the party's perceptions of who is a good mediator and who isn't a good mediator. And
right.
generally, mediators are very rarely appointed by
Right.
the court, unless they're court officials or whatever.
Right.
So, and generally the parties get it right. I mean, you know,
Well, that's
the
interesting.
people that are good mediators tend to get most of the mediations.
Yeah.
Because
Well, that's a fascinating, there's so many fascinating things in what you just said. First of all, the reason why I went to all that trouble is because in my court, my program is designed, the guy who made it this way. My job is to select the mediator. Now, I have done a little, it says it right in the court rules. I've worked around that. The Court of Appeal is a very, very, you're nobody's going to San Francisco soon, are you? Yeah, well, just, you know.
There's a nod at the back.
Okay, you don't say this in San Francisco. The Court of Appeal is a very rigid institution. Change doesn't come easily to the Court of Appeal. So when I first arrived, I had all these ideas about what ought to be different in the program. One of them was that this is kind of dumb to have me pick the mediator, but I learned very quickly that I was going to be picking the mediator. So I've done some work around. I think you're right. Again, and this is belief. This is belief. I think you're right, and probably could be proven right, that parties' involvement in selection of the mediator probably has some discernible and verifiable effect downstream once the parties get to the mediation table. So I had to meet these people, and again, since my job required me to appoint them, I wanted to know who they were, just to get a feel for what they were like if I was going to send people to spend a whole day with them. Also in your question, though, was this very interesting point about the market getting it right, people knowing who the good mediators are. I'm not a supply side guy. I'm not a market guy. I come from a different school of thought. You did a nice job in my view, when you said the markets of people's perceptions of what good mediators are borne out by the fact that good mediators tend to get hired again and again and again, or that mediators get hired again and again and again turn out to be what it is that people want. And there may be an effect, there's some hypotheses floating out there that simply believing that the mediator that you're getting is good is a step in the right direction of getting cases settled. One of the things that I didn't point out is that there is so far the only demonstrated correlation between anything about the mediator and settlement rate is the number of the mediations the mediator's done. The more mediations you've done, the higher your settlement rate becomes. So, but why lawyers pick mediators is a very interesting question. In the States, except in divorces, the lawyers do the selecting. Parties don't know mediators. Claims insurance people have lists of mediators that they will use. A lot of times the lawyers will, ask me, please appoint a retired Court of Appeal justice to mediate the case. These people haven't spoken to a human being in 20 years. They don't speak to people.
I'll go here and then.
Gary, at the beginning you mentioned that the origins of the mediation movement came from the hippies, and you were saying that the goal was to create a society that could resolve its own problems. Is that?
Well, that's not quite what I said, I think, but I did say it came from the hippies, but that was a shorthand and sort of poetic way of saying it came from the cultural changes and the political changes in the 60s and 70s.
Because I'm wondering, is that then the goal, just that we do develop a society that is able to handle its own problems? So is the settlement really the goal then?
Well, okay. So I did try to make clear that my personal philosophical views, which I'm sure of great interest to all of you, they're of great interest to me. My personal views are that settlement is one of many valid goals for mediators to bring to their work and for people to seek from mediators. There are a whole bunch of other goals that I think are tremendously useful and tremendously important. Understanding, repairing relationships. I mean, some of my most satisfying moments as a mediator have been when those other goals were being served. The thing about the 60s and 70s was a little bit less than that. The part that interests me most is the idea that in our neighborhood, in our little community, we would like to, this is the community mediation movement, we would like to resolve our disputes amongst ourselves here in this small is beautiful kind of way, using non-professionals, using our neighbors as our helpers. And with full acknowledgement that there is a legal system out there to choose the criteria and the standards of behavior that we want to apply and not get trapped in the legal analytic framework of causes of action and all that. It brings up another thing that I've become to feel very strongly about, oh boy. So in California, we have a very, very strict confidentiality rule. It's the most robust confidentiality rule, I think, of any jurisdiction I've ever encountered. In fact, we had a Supreme Court case just this past year in which the Supreme Court basically said that because mediation communications are so confidential, I got a mediation on Wednesday. I'm the client. I'm Mr. Castle, is his name. I've got a mediation on Wednesday. On Monday, I go to my lawyer's office and we talk about the mediation. We plan for the mediation, what we're going to do. Tuesday, I go back to my lawyer's office and we talk about the mediation and what's going to happen to the mediation. I tell my lawyers what I want. They tell me what you want. On Wednesday, we go to mediation. We're in mediation from like 9 o'clock in the morning till like 9:30 at night. I have conversations with my lawyers with just them. I have conversations with my lawyers with the mediator present. I have conversations with my lawyers when I'm in joint session with everybody. I have conversations with my lawyers when I'm in the bathroom, and I have conversations with the lawyers when I'm running down the street trying to get away from the mediation, really, truly. Settle the case at the end of the night. The next day I go see a new lawyer who said that your lawyers committed malpractice in the way they dealt with you in mediation. I sue my lawyers. This is a true California case. And by the time we get to the Supreme Court says no, all of those conversations on Monday, Tuesday, and Wednesday were all in furtherance of and in preparation for the mediation. They are not admissible in the court, and therefore you can't sue your lawyer. Well, there's a big hue and cry you might find understandably in California among people who know about this. Anyway, there's like 10 of us. How can we have a system? How can we have this process, especially one that's connected to courts in such an intimate way, in which people can't sue their lawyers who they're spending all this money on for malpractice? And you really can't. For malpractice in mediation, you can't sue your lawyer. And it raises for me, it brings me back to some of the original impulses that led to this use of worldwide use of mediation, which was that the community mediation scheme was a non-professionalized dispute resolution process. Nobody was going to sue anybody over what happened. There were no standards of care by which the community mediators would be judged. They didn't need judicial immunity. They didn't need immunity from anything because it wasn't a profession. No one was paying for it. And I'm trying to get a conversation going in California about whether or not, because there's a movement to change the confidentiality statutes in California to allow for some of these things to come in so that you can sue your lawyer. But I think that there's a place for this thing called mediation that is a different breed of cat, in which everybody agrees we're going in to do something very different. And we're not going to sue the mediator for screwing up. We're not going to sue the lawyers for screwing up. And we're going to just talk to each other.
One more, just over here, and then I think we'll have to close up because we're running a bit over.
Gary, George said that the market selection generally got it right. I'm curious in relation to your process. You have the role of selecting mediators. Presumably you selected the mediators that you thought were going to be more appropriate to settling the appeal. What criteria did you use in selection that wasn't based on success rates, for example?
Well, when my predecessor trained me, we looked at the database, and there's 230 mediators in the database, and we have success rates for those mediators. There are, out of the 230 mediators, maybe 50 who've mediated 10 cases over the 10-year history of the program. So if you look at their success rates, some of them are 100%, some of them are 50%. Most of the mediators have only mediated 3 or 4. So success rates on 3 or 4 mediations, what does that mean? It doesn't mean much. Honest to God, when it comes down to me appointing somebody, I rely on a couple of lame things. Do I like this person? Do I think that they're going to get along with people? What is this dispute about? Is the dispute about interpersonal stuff and its core? Is it going to need somebody who can actually deal with that stuff? Or is it really a case in which what we want to do is get a court of appeal, retired court of appeal justice in there to tell them you're going to lose and you better take the money and run? And then I happily bring up the retired justices of the Court of Appeal and ask with great humility if they'd be willing to serve as mediators in this case. So I'm still not saying I know what I'm doing. Sorry.
Great point to finish on. Now we do aim to have a little bit of controversy in these talks, and I think it's really important that we do as part of our ongoing conversation. I hope you can join with me, not in threatening to kill our guest speaker, but actually join with me in thanking Gary for coming along. He has been actually working all day today as well as part of our mediation program, and we're delighted to have him along as a coach on our program, and thank Weiner very much for ensuring that he could be accredited, which was a wonderful thing to do. Deborah's in the audience here, but it's really interesting, I think, for us to think about many of the issues that Gary raised, and I want you to join with me in thanking Gary in the traditional way. We have a small, a very elegantly wrapped gift again. Yes, the traditional Monash hat that we send all of our overseas speakers home with. Thank you. And thanks to everybody as well for attending this evening.